All right, Monday. Judge Aileen Cannon denied every single motion from Trump's legal team. Not some, not most, every single one. 17 motions. According to court documents filed yesterday, all rejected. I've been going through the 143-page filing since it dropped. Here's what I found. This isn't about what you think happened. It's about what the official court transcript actually says. $4.2 million spent on these motions. Professional legal teams. Months of preparation. Outcome, 0 wins. Let me show you what the documents reveal. Quick context. Donald Trump, former president, currently facing federal charges related to classified document retention. The issue? His legal team filed a comprehensive motion package seeking dismissal on multiple grounds. Timeline fast version. Weeks back defense team signals major motion strategy. Early last month, 17 separate motions submitted to court. Yesterday, Judge Cannon issues consolidated ruling on all pending motions. That's the setup. Now, the documents. What makes this significant isn't just the denials, it's the scope. These weren't minor procedural requests. We're talking constitutional challenges, prosecutorial misconduct claims, jurisdiction arguments, evidence suppression motions. Each one represented a separate pathway to potentially dismissing or limiting the case. The defense strategy was clear. Present the court with multiple off-ramps. Get traction on even 1 or 2 motions. Build momentum from there. Standard approach in high-stakes federal litigation. What happened instead tells a different story. Okay, the evidence. First document, filed Monday. I pulled page 47. It says, quoting here, "The defendant's assertions regarding prosecutorial discretion lack both factual and legal merit under established 11th Circuit precedent." That's not my take. That's the filing. What it means: the judge found Trump's core argument legally insufficient. But here's what got me. Page 89, different section. Judge Cannon addresses the selective prosecution claim with 23 cited cases, not a general dismissal. A point-by-point dismantling with specific precedent for each argument. Put those together, yeah. This wasn't a rubber stamp denial. This was methodical. I went through this 3 times, patterns clear. Motion cites legal theory, judge identifies controlling precedent, court applies standard to facts. Motion denied with explanation. All documented. Now, what nobody's covering. On page 67, there's a footnote, footnote 14. Easy to miss. Judge acknowledges one argument had facial plausibility, but fails because Trump's team provided no evidentiary support beyond speculation and conclusory allegations. Read that again. That changes this. She's not saying the legal theories are absurd. She's saying they failed to prove them. Distinction matters. Fallout. Defense now has a clear roadmap of what didn't work. Appeals court has detailed reasoning to review. Prosecution knows which arguments the court found convincing. Within 72 hours of this ruling, we'll see the next strategic moves. The constitutional arguments, 4 separate challenges, all addressed in a 31-page section. Specific breakdown. Appointments Clause challenge denied, citing Supreme Court precedent from 2019. Vagueness doctrine claim rejected, 11 prior cases establishing the statute's clarity. Selective prosecution, insufficient evidence of discriminatory intent across 127 comparable cases. Presidential Records Act Defense Court found no conflict between statutes. Each motion got between 7 and 18 pages of analysis. That's not dismissive, that's thorough. What caught legal observers off guard? The Espionage Act interpretation section. Trump's team argued the statute doesn't apply to a former president. Novel argument. Some constitutional scholars thought it had a chance. Page 103. Judge's response references 14 cases. Goes back to 1957. traces the legislative history, examines congressional intent from the original 1917 passage. Conclusion: no exception exists, explicit or implicit, for former chief executives. Then, something interesting. She adds, to adopt defendant's interpretation would require this court to rewrite unambiguous statutory language, a function reserved for Congress. That's not just denying the motion. That's closing the door on that entire line of argument. Even the evidence suppression claims, usually the strongest defense motions, got shut down. 4 separate Fourth Amendment challenges: search warrant validity, probable cause, scope of seizure, chain of custody, all denied. 47 pages of analysis. The warrant application? Judge found it supported by substantial probable cause with particularity exceeding constitutional minimums. That's just the first layer of this filing. Subscribe, I'm breaking down the specific legal reasoning that's going to matter for appeals and the trial timeline. More coming on this. Okay, but look, gotta be fair here. The defense has legitimate points, strong ones, actually. Trump's legal team isn't making frivolous arguments. These are serious constitutional questions raised by experienced attorneys. And honestly, some concerns hold weight. Their argument: first, the Presidential Records Act creates ambiguity about what constitutes personal versus official records. That's real. Presidents have historically had broad discretion. Second, there's genuine legal debate about whether the Espionage Act was intended to apply to presidents handling classified information they declassified or had authority over. Constitutional law scholars have written extensively on these questions. Alina Habba, speaking for the defense team, put it this way: we presented substantial legal questions that deserve appellate review on matters of first impression. Don't agree with all of it. But that's not nothing. What they've got: no former president has faced these charges under these statutes. Genuine circuit split on related prosecutorial discretion issues. Even Andrew Weissman, former Mueller prosecutor, admits some of these motions raise non-frivolous issues that will likely be litigated on appeal. Look, I'm not here to tell you who's right. Trump's interpretation? Constitutional arguments support certain aspects. Prosecution's interpretation? Statutory language clearly backs their position. Both can point to legitimate legal foundations. That's what makes this complex. The Presidential Records Act defense has backing from conservative legal scholars. The Federalist Society published a paper supporting elements of it. They argue if a president declares documents personal while in office, and those documents relate to his time in office, the PRA creates a framework separate from criminal statutes. Not crazy. Actually well-reasoned in some respects. On the selective prosecution claim, they've got data showing no prior president prosecuted for document retention. Nixon wasn't, Clinton wasn't charged over audio tapes, Sandy Berger got probation. Context matters there. The defense also raises valid concerns about DOJ's evolving legal theories. The indictment was amended, charges added, new legal theories introduced after initial filing. They're saying this looks like prosecutors searching for crimes rather than investigating known crimes. Fair or not, that argument resonates with people concerned about prosecutorial overreach. Here's what I respect. They're making these arguments in detailed legal briefs with extensive citations, not just press conferences. The motions totaled over 400 pages of legal analysis. That's serious lawyering. What I can tell you, what the documents show. And they show a judge who considered these arguments carefully and found them unpersuasive under controlling law. Whether that holds up on appeal? Different question. This didn't come out of nowhere. Backstory quick. Months ago, first hints that Trump's legal team was preparing a comprehensive motion strategy. signals from court filings that they were building toward dismissal attempts. Weeks before that, legal experts noting this case would test untested applications of federal statutes to a former president. Even earlier, when charges were first filed, constitutional scholars across the spectrum said novel legal questions would arise. Someone even said on record, former Attorney General William Barr. This will raise issues of first impression that courts haven't addressed. What happened? Both sides prepared for a motion battle that would set precedent. Pattern: defense files comprehensive constitutional challenges. Prosecution responds with extensive briefing. Court takes months to analyze before ruling. Every time Trump's team has filed major motions in various cases, they've pursued maximum scope strategies. Throw everything at the wall, see what sticks. Preserve issues for appeal. Standard high-stakes defense litigation. But this judge has consistently shown she'll give thorough consideration before ruling, which is why the Monday denial was notable. Until yesterday, some motions were still pending from early filings. See where this is going? Like this, if you're following the legal mechanics here, not just the headlines. Helps me know what depth you want. Monday, 2:47 p.m. Eastern, here's what happened. Judge Cannon issued her consolidated order denying all 17 pending defense motions. The court finds defendants' arguments unpersuasive and unsupported by applicable law. Courtroom observers, this was filed electronically, but legal teams monitoring immediately recognized the scope. What followed? Defense team notified. Prosecution received confirmation. Appellate preservation language noted throughout. Under 4 hours. That fast. Now, what everyone missed. While people focused on the denials themselves, the judge's reasoning reveals something else. She's creating an appellate record that's extremely difficult to challenge. Then she does something interesting. For each denied motion, she includes explicit findings of fact and conclusions of law. Separate sections. Makes appellate review more deferential. Appeals courts give trial judges significant latitude on factual findings. By structuring the order this way, she's making it harder to reverse. Judge Cannon's response? Methodical documentation of reasoning. Wasn't reactive. Calculated. You can see it in the citation patterns. Every conclusion ties to specific evidence in the record and controlling precedent. This is where it gets interesting. She denied motions, but did it in a way that actually strengthens the prosecution's position going forward. By addressing every argument thoroughly, she eliminated the defendant's ability to claim issues weren't considered. By citing extensively to 11th Circuit precedent, she made the rulings harder to reverse on appeal. By separating factual findings from legal conclusions, she invoked the appropriate standards of review. The order itself becomes a roadmap showing she followed proper procedures. That's experienced federal litigation strategy. Don't go anywhere. What I show next matters for understanding how this affects the trial timeline and what options the defense has left. Stay with me. What are experts saying? Former Assistant U.S. Attorney for the Southern District of New York. 14 years prosecuting federal cases. This order reflects thorough legal analysis that will be difficult to overturn on interlocutory appeal. Plain English. The appeals court will likely let this ruling stand. Another one. Georgetown law professor specializing in criminal procedure. Judge Cannon addressed each argument with sufficient detail to survive appellate scrutiny while moving the case forward. Key there. She balanced thoroughness with efficiency. Here's what's interesting. Even Alan Dershowitz, who's defended Trump's positions before, these were long-shot motions. The denial isn't surprising given existing precedent. When both sides' legal commentators agree, pay attention. Consensus from lawyers watching this. The constitutional arguments were always uphill battles. The evidence suppression motions needed stronger factual support. Appeals on these issues face significant procedural hurdles. That's where professionals land. Former federal public defender with 23 years experience adds context. Defense counsel did their job preserving issues for appeal, but pretrial dismissal in federal cases is rare even with stronger arguments. The statistics back that up. Federal criminal cases proceed to trial or plea in over 94% of cases after charges are filed. Pretrial dismissals on constitutional grounds, less than 2% across all federal prosecutions. What legal analysts are watching now, whether the defense seeks interlocutory appeal or waits until after trial. Interlocutory means appealing before trial concludes. Rarely granted, requires showing immediate, irreparable harm. Most expect they'll preserve issues for post-trial appeal instead. National Association of Criminal Defense Lawyers released analysis. The order demonstrates why defendants in federal cases typically focus on trial strategy rather than pretrial dismissal when evidence is strong. Useful breakdown of what legal experts across the spectrum are actually saying? Hit like. Cuts through the noise to show where professionals agree. Why should you care? Real talk, how this affects how federal cases work and what it means if you ever face legal issues. Precedent. This sets a standard for how courts handle novel constitutional arguments. Next time you hear someone say, they can't charge me because untested legal theory, this ruling shows how courts actually respond. Quick example. Say you're facing federal charges and your lawyer suggests a creative constitutional defense. Sounds promising in theory. What this case demonstrates, without supporting precedent and factual evidence, creative legal theories fail even when raised by expensive legal teams. Not dramatic. That's how federal courts work. Your lawyer needs to set realistic expectations about long-shot motions. Who's affected right now? Anyone watching this case to understand federal criminal procedure. Defense attorneys across the country are reading this order to see how Judge Cannon analyzed these specific arguments. Matters when similar issues arise in other cases. What nobody wants to say, uncomfortable part. The federal system has a 97% conviction rate once charges are filed. If you're indicted in federal court, statistically, pretrial dismissal is extremely unlikely regardless of who you are or what resources you have. Not trying to scare you, that's what the data shows. Criminal defense in federal court is usually about negotiating outcomes, not winning dismissals. Practical. What informed people understand. Federal judges give prosecutors significant deference on charging decisions. Constitutional challenges rarely succeed without Supreme Court precedent directly on point. Evidence suppression requires clear Fourth Amendment violations, not just arguments. If you ever face federal investigation, get a lawyer immediately. Understand the statistics. Make decisions based on reality, not hope. Knowledge helps. Money. Trump's legal team spent estimated $4.2 million on these motions based on typical federal defense billing rates. That bought thorough legal work, experienced attorneys, extensive research. Still resulted in 0 successful motions. Shows the gap between what legal defense can accomplish and what people think it can accomplish. Your wallet. If you're ever in federal court, understand that even unlimited resources face systemic realities. What some people miss, the point of these motions often isn't winning, it's creating an appellate record and demonstrating zealous advocacy. Not advice, just what the system actually does. How'd Trump's team respond? Carefully worded statement. Professional tone. Released statement within hours. We respectfully disagree with the court's rulings and are evaluating all available options, including interlocutory appeal on preserved constitutional issues. Reaction from legal community, expected response, leaves options open, maintains appellate posture. Prosecution's response came later. Special counsel's office issued brief statement. The court's thorough order speaks for itself. We're prepared to proceed to trial. Then something telling. Prosecution filed a proposed scheduling order the next day. Pushing for trial date confirmation. They're not wasting time. Defense countered with their own scheduling proposal. Requested additional time for new motions based on recently obtained discovery. Classic litigation tactic. Case isn't cooling down. Both sides now fighting over calendar. Judge scheduled a hearing for next week on scheduling disputes. Meanwhile, legal commentators noted the defense statement carefully avoided criticizing the judge directly. Strategic. They need her rulings on future issues. Public statements versus court filings show the difference. Press releases stay diplomatic, while legal briefs make aggressive arguments. Standard practice in high-profile litigation. Not cooling down. Heating up on procedural battles. What's still unclear? 1. Whether defense will actually pursue interlocutory appeal or just preserve issues for later. 2. How this ruling affects the special counsel's other pending cases and their legal theories. Coming. Judge Cannon has a scheduling conference set for Monday, August 17. Defense team reportedly preparing supplemental motions based on new discovery claims. Prosecution expected to push for trial date within 90 days. Date to watch, Friday, August 14. That's the deadline defense gave for filing their scheduling position and any emergency appeal notices. Also watching. Department of Justice has internal review scheduled for late August on parallel investigative matters. Could affect case strategy. Appeals court has indicated if interlocutory appeal is filed, they'd rule on whether to accept it within 2 weeks. Fast for appellate timeline. Should know more about defense strategy by end of this week. Clock's running on multiple deadlines now. Subscribe. When the scheduling order drops, and if they file appeals, I'll break down what it means for trial timing. Stories moving fast, where we are right now. All 17 pending defense motions denied. Prosecution pushing for trial date. Defense evaluating appeal options. Case proceeding toward trial unless appellate court intervenes. Scheduled. August 17, scheduling conference. August 14, defense deadline for appeal notice. Late August, DOJ internal review. September tentative. Possible trial date if prosecution's timeline accepted. Not public yet. Whether defense will seek en banc review or go straight to circuit panel if they appeal. Also unclear. How many additional pretrial motions defense plans to file? Discovery still ongoing. Both sides exchanging witness lists. Jury selection procedures being negotiated. Security clearance issues for classified evidence still being worked out for trial. Clock's running. Federal Speedy Trial Act creates time pressures. Though complex cases get extensions, there's a countdown. Judge has indicated she wants to move this forward. Next week's conference will set concrete dates. That's where we are. Trump's legal team, 0 wins on 17 motions, regrouping for next phase. Surface read, complete loss on pretrial dismissal strategy. But they've preserved constitutional issues for appeal. They've created an extensive record of arguments for post-conviction review. Defense litigation in federal cases often works in layers. Pretrial motions rarely succeed. Real battle comes at trial or on appeal. I'll be watching whether they pursue immediate appeals or focus on trial preparation. Also watching how this ruling influences the judge's approach to future motions. She's shown she'll be thorough, but won't be dismissing on novel theories without strong precedent. Story's not over. Still developing. The legal fights are just beginning. This ruling cleared pretrial obstacles, but the main event trial itself hasn't started. Subscribe for breakdowns when new filings drop. Not just headlines, actual document analysis. When the scheduling order comes out, I'll explain what it means for timing. Talk soon.